All right. Hello there. Good morning, good afternoon, or good evening from whatever time you're watching this recording. My name is Sarah Baldwin, and I work as the Program Director with Cancer Support Community North Texas. If you're not familiar with our organization, we offer free support services for anyone impacted by cancer. We are very pleased to be joined once again by Cynthia Asencia, who has over 32 years of experience as a practicing attorney. She has a special heart and passion for educating folks impacted by cancer on what are the legal documents and steps to be done, taken in order, just to make sure that everything is as easy as possible for your loved ones in the ultimate time that someone passes. I'm gladly going to be handing over the microphone to Cynthia for this recording.
Thank you, Sarah. I'm so glad to be here and thank you for inviting me back. And I'm thrilled to help people think through the issues that might pertain to their both what we think of as their life and estate planning. What I'd like to do, I'm going to provide a lot of information in the slides for people today. That way, if it's hard for them to take notes, they can come back to this and really, fine tune it, review the slides again. So there's a lot of information ingrained in each slides. And I really want to thank the Cancer Support Network for doing such thoughtful programming for all of your members and visitors and folks who are impacted and or walking the journey with someone with cancer. I've walked that journey with family members of my own, and I know how important estate planning is. So I'd like to just jump in. I've been a licensed attorney a long time, as Sarah said, and I'm here to help answer questions and to make some of these issues a little bit easier to understand, and happy to talk to folks, privately, confidentially with any questions that you have. So let's kind of jump in. So one of the things Sarah mentioned is, that I sort of have a heart and a passion for this work. And a lot of that is because of my family background and my family history. I've had a number of family members who passed away from different types of cancer. So it brings me to this support group in particular, with an affinity for the work that you all are doing. But I also, as a young person in law school, I got an opportunity to help with my grandfather's probate of his estate. He passed away while I was in my second year of law school, and I was asked by my family to find the probate lawyer to handle the estate. And it was a really good learning experience, and it really solidified for me the importance of this kind of work with estate planning in particular, because when I was going through the process with him and when I had to care for my mom at the end of her life, I was lucky. All of my family members had done all of their estate planning. So for each of them, the process of working through probate and wrapping up their affairs was actually very straightforward, very simple, and really only took about 6 months, which that is the hope I would have for anybody, that we can help you be empowered. We can educate you about the topics that you need to be thinking through and help plan for things, even if they are decades away, that we've done planning for your future. This type of work, the estate planning field, this is really the one area of law that every single one of us is going to have to interact with, whether we like it or not, or our family members that we leave behind are going to have to, work through this process on our behalf. So I want to educate, I want to empower, and obviously help people to sort of take that weight off of their shoulders by getting this work done, making the decisions for themselves, and having agency and autonomy. We can really help set you and your family up to both preserve your legacy and to protect all of your assets. So a lot of people sometimes are not certain if they need estate planning, and absolutely every single person, particularly in Texas, if you are married, because we have a community property state, if you own anything, a car, bank accounts, a 401k, a home, yes, you want to have your estate planning in place, because part of what we're doing is helping you be the leader in your family, even in a period where you may be disabled or unable to make decisions for yourself. And certainly when you pass away, we want you to be able to share that legacy with all of the people that come behind you. And so part of what I'm trying to do is help people think through, how can I have a good handle on my assets? Am I making good financial decisions? What kind of healthcare planning do I need? If you've got kids, we have to do special planning for them as well. So it's really important to think through these issues in a thoughtful way, in a deliberate way, but not being impulsive. And one of the things that estate planning lawyers do is help people protect their assets. We help make sure that your finances are organized in a way that makes sense, that you have the right kinds of insurance, that we know how your real estate, if you own any, how it's titled. If you're married, we obviously are going to address property issues that would relate to community property. We're dealing with transferring assets to kids, thinking about all of your bank accounts. And something that a lot of people don't think about is their digital assets. And a lot of lawyers didn't really start talking about this until about 10 years ago. And part of the reason for this is people don't really know what digital assets are. It's basically think of any device that you own, computers, cell phones, smartwatches, anything that connects to the internet is part of your digital assets. And any websites where you may have username and passwords, those are technically assets of yours. And all of those things will have to be cleaned up at the time that you pass away, or if you're incapacitated, someone might need to access those online portals for you. And we want to make sure your family members and folks that you might have designated under a power of attorney know what those are and know how to access them. This this screen looks a little funny that everything must go, but a lot of people don't realize, that when you die, this is actually the single largest financial transaction that you will ever make, because every single thing worth every dollar that has your name attached to it, everything transfers all at once. Yes, you may have to go through the probate process to refine which assets are sold or liquidated or how they're distributed. But the moment of death causes every single thing to get triggered to change hands. And part of what we're trying to do is help people think through what is going to happen at that point and how do you want those assets to get transferred. Let's kind of back up a little bit. A lot of people, they understand that or maybe they've had a family member that's had to go through the probate process. So this is sort of the endpoint. Probate would be the last stages after someone dies. If there's anything that needs to be cleaned up and the courts need to be involved with to settle all of your affairs when you pass away, that is what the probate process is for in every single state. The state's interest in you and your death and your belongings is really only focused on transferring title to assets. The state of Texas wants to make sure if you have a house that is going to be sold or given to a family member, that the title is clear. The probate process can help make that happen. We want people who might acquire an asset, a house, a car, insurance proceeds. We want to make sure that they get those things free and clear and entirely in their name. One of the other things that the probate process can be used for is to help ensure that all of the debts of somebody who has passed away actually get addressed and taken care of. And sometimes the probate process can be used almost like a mini bankruptcy. If somebody has a lot of different debts when they die, they may only get paid 10 cents on the dollar if there are not a lot of assets to pay all those bills. So if you've heard, people saying try to avoid probate, no, I don't believe that's a correct statement. The probate process can be extremely beneficial, especially for people that have a lot of debts that need to be resolved. But the rest of the probate process is about clearing things up, making distributions to your beneficiaries, and making sure that a final tax return gets filed. A lot of people think, again, potentially mistakenly, that you have to rush as soon as someone passes away to get the will and run to the probate court and get your letters of administration and get an executor appointed. That's not true. You have legally in Texas 4 years to open a probate proceeding. So it might be that there are a lot of things that could be resolved and taken care of, especially if the estate planning was done well. And you may never have to file and open a probate proceeding, or you may be able to wait, clean up a lot of things so that the probate issues will be minimized and the process will be more streamlined. There are also some alternatives to probate in Texas, and you may have heard of these before. One is called the muniment of title, affidavits of heirship, and small estate affidavits. They're not used as often, and you can see some little caveats there as to when they might apply. But some folks don't need a full-blown probate proceeding. They can use one of these alternatives to probate if there's maybe only one thing that actually needs to get dealt with. Like maybe there's a will, but the only issue we're having is how to sell a home and change title to the home. You might be able to just do a muniment of title action for that. The probate process itself, if there's a valid will, so the person dies, you find the will, you take it to the court, the judge says, yes, this looks like a valid will. They open the probate, they give you your letters of administration. That starts some timetables running. And that's usually in the first 90 days, there are a variety of things that have to be done. But after that, it may be that someone can clean up an estate quickly. So I just tell people, don't be afraid of the probate process. If you get your estate planning done well and thoughtfully, and you stay organized during your lifetime, you may be able to avoid probate altogether, or it may be very minimized, which anytime you're saving time with a lawyer, you're going to be saving money. So that's just a quick overview of how the process works. This is kind of a flow chart that you can look at again later if you want to, but it talks about receiving the will, appointing an executor, posting bond is in here. If the will is done correctly, you can put in the will that you don't want the court to require a bond. So that's helpful for your executor. They don't have to basically insure themselves while they're doing their work, relocating all of the assets, identifying what somebody owned, determining what they're worth, notifying all the creditors so that if there are any debts that still need to be paid, those can be resolved, paying out the debts, filing tax returns, and anything that's left over that needs to be distributed, which could be oftentimes it might just be cash, the actual money sums from a bank account. We know what's left that can be distributed at the end. So that's sort of a quick flow chart. People don't always know what we mean by what is a probate asset and what is not a probate asset. And in this work, in estate planning, lawyers are thinking about this in two different ways, and as are the courts. So typical probate assets, this is every single thing that you own. Any material, physical object that you own would normally be a probate asset, something that has to be dealt with through your will and the probate courts. That also includes, you'll see one of the images in here shows a bunch of little pets. Your pets are considered personal property. Those can also be addressed in the will. They would also be a probate asset. The gentleman that's got his stamp collection, if you have collectibles or particularly valuable items, those also are probate assets. What a lot of people aren't familiar with is the non-probate assets. And when a lawyer says that, a lot of times people are a little confused. What that means is there are things you likely own that can be avoided in the probate process. Those include bank accounts, any kind of investment accounts, 401ks, annuities, etc., and your life insurance policy. And the reason those things don't have to go through probate, if you've set them up correctly and you're using beneficiary designation forms correctly, you're telling that institution, your bank or your investment advisor or the brokerage or the company that handles your 401k or the life insurance company, each of them has their own forms. And so you can tell them who you want those funds to go to in the event of your death. They each have their own forms. You have to fill those out with them. So part of what we do as lawyers during the process of working with clients is we make sure that your beneficiary designations are in alignment with what you're wanting to do in your estate planning. And a lot of times people will realize, oh, maybe I filled out a beneficiary form with my HR director when I first started a job 15 years ago, but it no longer matches where I actually want the money to go. So that's one thing we encourage people to do is go through all of these kinds of accounts, get your beneficiary designation forms or payable on death forms or what sometimes the bank calls them. We want to help get those things updated so that you are very clear about who you want to get that money in the event of your death. And the person that's going to receive it can basically just go with proof of their identity, your death certificate. If they're named on the designation, the money can transfer directly to them without them having to go through the probate process. So that is a big deal. That's very important for us to help clients go through that. For people who don't have a will, every state has their own intestacy laws, or we think of it intestacy inheritance laws. So a lot of times you may hear estate planning lawyers in Texas joke a little bit, and they'll say, if you don't have a will, the state of Texas has one for you. That is because written into our state statutes are this crazy pie chart that you're seeing here is a visual depiction of how the intestacy laws in Texas work. So if you don't have a will and you die, the state of Texas, the probate judge, is going to make a decision about how assets are divided, depending on whether you're married, whether you're single, whether you have children, parents, et cetera, et cetera. And it, as you can see, just from looking at this without even reading them, you can tell it could be a little messy and confusing. So you really, really, at a minimum, want to have a valid will that could be entered into probate so that you're not leaving it up to the whims of the state of Texas, our laws, and the courts having to decide who gets what. One thing I will say, this is just one little slice of one of those charts. In Texas, the statutes for intestacy really favor children first. We are looking for descendants, so people below you on the family tree, your kids. If you don't have descendants, then we're looking above you. We're looking at your parents. If you don't have surviving parents, then we will start looking sideways for siblings, sisters and brothers. But sometimes people don't realize because we're in a community property state, we get an extra twist on this. So again, if you die without a will, this example says you're married, you have children with your current spouse. You can see the state is looking at community property there on the left in the big blue bubble differently than it looks at your separate personal property or your separate real estate. So if you're married, but you owned the house before you got married and you didn't add your spouse to it, that is your separate real property. And if you die without a will, your spouse is only going to get a 1/3 life estate. Everything else is going to go to your kids. This can be really confusing, stressful, and can create a lot of anger in families. So one thing you want to talk to an estate planning lawyer about is really making sure the lawyer knows, and they will ask you, I will ask you, how your property is held. What does the deed say? Is it yours? Is it yours with somebody else? Is it yours with your spouse? Because we want to make sure if what you intend is for your home to go 100% to your spouse, we need to make sure your will says that. This is another example. What if you're married, but maybe this is a second marriage and you have children from your prior marriage? This really gets messy. You can see the bubble on the left with community property. So even if the house you are currently living in, you own it with your current spouse, if you have children from another marriage or another relationship or any other human other than your spouse, those kids are going to get half of that community property. So again, this creates a lot of problems at the courthouse. And that's even the house you own with your current spouse. Your children from a prior relationship will legally get half of it. So I cannot tell you the amount of fights that happen at the courthouse over this, what is an unintended consequence. So you really want to make sure your will reflects how you want your property divided, especially things that you think you own with your spouse. They may not all go to your spouse if you don't have a will. So that's really important. This is just another little slice. Sometimes people are, maybe they're not married and they don't have any children. This is just showing you how we look at if there's no kids, we're looking to see if your parents are surviving, maybe only one parent surviving. Do you have any siblings? Again, if you don't have a will, this is how the state of Texas is going to want to divide everything. So you can go back, you can Google those, you can just Google Texas intestacy laws. You'll see lots of different images of these pie charts. But for most people, they don't realize how complicated it can be. And you could avoid all that drama, all that confusion, and all that stress for your family members just by doing your will. This is also married with no children. So if you're married but don't have any children, your separate real estate. So again, let's say you own a house, it's just in your name. You happen to be married, but that person is not on the deed to the house. You don't have kids. Now we start looking at parents and siblings as well. So again, can be very confusing and really, really for the surviving spouse, it can be really devastating if they start realizing that they may not be able to live in the house that they thought they were going to get to keep because you forgot to put it in your will, you forgot to draft a will. So very important. Let's kind of just take a back out a little bit. What are all the documents that an estate planning lawyer like myself or most estate planning lawyers, they're going to draft for you 7 different types of documents. Some of them only kick into place when you die. Some of them only work while you're alive, and they stop their legal effect the minute that you die. So this list of 7 are the things that would get created for you. Obviously, the will, and then the powers of attorney. The first one, the durable power of attorney, that is for all your financial matters. So if something happened to you, maybe you are in the hospital for an extended stay, or maybe you're seeking some kind of medical treatment, but it makes it hard for you to think or stay awake or be clear-headed, or you're tired all the time and you just need some help making financial decisions. That's what that durable power of attorney is for. It lets you tell the world who you want to make financial decisions for you when you're not able to do so for yourself. Medical power of attorney, that's pretty self-explanatory. Who would you want to make medical decisions for you? Again, if you're incapacitated in some way and not able to make medical decisions for yourself. Obviously, if someone is unconscious, maybe they've been in an accident, they're in the hospital, they're in surgery, the doctors might have to talk to someone under medical power of attorney. So you definitely want that. The directive to physicians, this is what we used to call the living will. This document lets you tell all of your medical professionals whether or not you would want every single possible medical thing done for you if you are in a terminal or irreversible condition, or whether you would prefer to have the doctors take a more cautious and palliative approach to just remove some of the other types of care and allow you to die more comfortably. Or you can just direct that the person who you've named in your medical power of attorney makes those decisions after consulting with your doctor. Because again, sometimes there are people where maybe they have a long illness, especially someone if they're on hospice care, for example, they may get to a point where they're not as able to communicate with the doctors. And so the physicians may ask about a directive to physicians and what the person wanted as their final wishes. Number 5, the appointment for disposition of remains. You can tell the world what you want done with your remains after you pass away. If you want to be an organ donor, if you want to be cremated, if you want to be buried a certain place, there's a spot to basically describe whatever you would want, and to tell, in particular, the funeral, mortuary, and cemetery services professionals, if you want certain things done with your remains, what you want done, and who is the person you're designating that can work with them to make those plans and guarantee they get paid. Um, Not everybody is going to end up using that document, but if you think there's any risk that someone in your family would disagree with your wishes, you absolutely want that, especially sometimes for people who want to be cremated. They may have a parent that wouldn't be on board with that decision. If that's important to you, you would for sure want that document. Number six, declaration of a guardian. It's not very common for people to go to court to seek guardianship over another person, but it does happen. All we do in that document is name the people that you've already named in your power of attorney for the financial and medical decisions. So if somebody ever went to court, said they want to get guardianship over you, you're pre-telling the judge, Judge, this is who I want you to appoint for my financial decisions and my medical decisions. And then the last one, the HIPAA authorization. Everybody's familiar with filling these out every time you go to a particular doctor, but usually that's for purposes of them sharing your information with your insurance company, and sometimes you might designate a spouse or one family member. This broader form can be used in every medical facility across the entire United States, and you can list as many people as you want who could access your medical records, talk to your doctors, etc. So usually we're putting in spouse and maybe some adult children or a sibling, something like that. There are some other documents that lawyers like myself will recommend to clients. And you might remember back a few slides, we were talking about non-probate assets. Well, there is a way to turn some of your probate assets into non-probate assets now. Most people aren't familiar with this. In 2015, so believe it or not, it's been 10 years now, Texas has joined a number of other states and the District of Columbia to allow you to use a transfer on death deed for real estate. So normally your house would be a probate asset, but if you used a transfer on death deed, if you filled it out, filed it in the county where the property is located, has to be on file before you die. But if you fill that out, now your house doesn't have to go through probate. Maybe you own a second home in the hill country. You could put a TODD on that and file it down in whatever county that might be. So this is a big deal for people, where we can help make yet another really large asset, one that should not have to go through the probate process. The second one is the vehicle beneficiary designation form. This also lets you designate to the state in advance of your death who you would want to receive your vehicle when you die. You could name a charity, you can name a person, but this again makes it really easy to avoid probate over a vehicle. And then the last one is just guardianship for minors. For people that have minor children, we're going to draft a separate guardianship paperwork for that minor so that if something happens to the parent, you're already telling the world who do you want to raise your child and who do you want to manage their money. That can be the same person, it can be two different people, but we definitely would be using that document for your children. So there are also a few additional considerations that lawyers have when we're talking to someone who's thinking about working on their estate planning. Blended families is one of them. We have a lot more prevalence of blended families, second marriages, third marriages, people who have stepchildren. Under all those little pie charts that I showed you, nowhere in any of them or in Texas law does it allow a stepchild to inherit when there's no will. They don't automatically inherit anything. If you have stepchildren and you want them to inherit from you, you either have to make sure you've used your beneficiary designations to help money go to them, or you need to make sure you have a will. And in the will, we can treat your stepchildren the same as your naturally born or adopted children. And I have many couples that do that, where both adults treat all the stepchildren as their collective children. There could be 5 kids, and both the husband and the wife will say, all 5 are my children. We have ways to describe it in the will, and they can all inherit equally if that's what you want. So that is a consideration for a lot of people. If you have minors, you cannot give money directly to a minor. They can't inherit it directly. It has to go through an adult human to manage the money for them. So specialized accounts have to be set up. If somebody dies and their will maybe wasn't written very well and it just says leave everything to my kids and it turns out your kids are aged 5 and 8, well, it can't happen that way. Now the court's going to have to go through some additional steps to create a specialized account for those minors. Someone's going to have to manage that money. So what we would normally do in the will, we will create, it's called a testamentary trust, meaning it's in the body of the will to name the person you want to be the trustee for your children's money. And that way you can say what it is you want them to get. Maybe you want them to get 50% of your estate, and you're telling the courts in advance, here's who I want to serve as the trustee. Here's who I want to be the guardian and take care of them physically. Here's when I want them to receive their funds. It could be age 21, 25. Most lawyers recommend you space it all the way out in chunks out to age 30, but it can be whatever you want to be, and that way the money can transfer more easily. Also, if clients have any type of business ownership, we want to talk about what your interest is in a business, how it's structured, how it's held. Is there already a succession plan in place for that business? And we probably are going to create an additional power of attorney. You might decide, hey, in my main statutory durable power of attorney, I want my spouse to have all the power over my money. But in my business, I want that to be a different person, not my spouse. Maybe it's your business partner. Maybe it's somebody else that you know would understand how to run the business and help wind down either the whole business or you're part of it if you're not able to make those decisions for yourself. Obviously, once you pass away, the powers of attorney, they cease to operate. And so if there's business issues that need to be unwound, that will typically take place as part of probate. One other additional consideration for unmarried couples, LGBTQ families, whether they're have children or not, any unmarried couples, it doesn't matter if they're gay, straight, it doesn't matter how they define themselves. We just want to make sure for those folks, since there's no automatic protection under community property law, that your wishes are being followed and that your paperwork and your will leave your assets to the person that you want it to go to or the entirety of your family. Pets, this is kind of a last one. I mentioned them before. They are personal property, so you can account for them in the will. Normally what I do is I identify the pets. My clients will say who they want to take their pets or adopt their pets. They may have a series of people, 1, 2, or 3. And if you want to leave a certain amount of money to the person who is willing to care for your pet, sometimes people will leave some money to help with vet bills or food or things like that. So we don't want to forget about our fur babies. We can definitely include them in the will. This is the last one, and this screen is meant to be scary because this goes back to the digital assets I was talking about before. Everywhere you have an online presence, an online account, you have to go through and think about all that. And if you haven't organized it in advance and something happens to you, how is your family member or trusted friend, how are they going to know what accounts you have, how to access them, what the passcodes are, how to make sure all your bills keep getting paid? Most people now don't keep anything in paper anymore. So, I'm that way. Almost nothing is in paper. Everything is online, including, you can see on here, like Microsoft 365. If you have all your data backed up to the cloud somehow, where is that? What software system are you using to back up all that data? You want to make sure we've thought this through. And if you have specific plans, we're looking here at some of these icons or social media accounts. Do you want your Facebook page to stay up if you die? Do you want a message put on it? Do you want it taken down? All of these things are things that you have power and control over. And if you don't make any decisions about it before you die, you're leaving quite a bit of work for your executor or your family members to try to sort this out afterwards. So one of the things I do with clients is work with them on getting this more organized. I have an Excel spreadsheet that I share with clients that will help them do that, at least for the top line things, especially anywhere that's connected to money or your credit card. If you have an Amazon account and your credit card is with them, that absolutely someone needs to know how to get into that and how to deactivate it in the circumstance where you're incapacitated or you pass away. Now, a lot of people will ask questions, or maybe they've seen something in the news or an article on social media about trust. So they'll say, oh, you need a trust. If you just have a trust, you can avoid probate. Well, let me start by saying that is not true. There is no trust that automatically guarantees you're going to avoid probate. And even we talked about the testamentary trust. That's the first one. That's if you want to leave things to a minor in your will. That's a trust in the will. The next one is the one most people are thinking about, revocable and irrevocable living trusts. People have heard about these, but they don't really know what they are. Even if you have a trust created, you're still going to have a will created as well. It's called a pour over will. That means anything you forgot to actually put into the body of the trust gets poured over and has to go through probate. In the United States, we just had Congress, in part of the legislation that they passed in June of 2025, they upped the limits of how much money you can transfer to other people during the course of your lifetime, where it's tax-free to them. So we think of like the gift tax. Now you can give up to $15 million per person. So if you and your spouse have assets of $30 million, you can give all of that away in your wills or in your lifetime without any tax consequence to the people who receive it. That is less than 0.1% of people in the United States. This is a very small group of humans that have assets over that amount. They definitely need trust work. Maybe someone has 3, 4, 5 homes around the country and extensive mineral interests, and they own lots of acreage. Maybe they have a ranch in Colorado or something. If you have lots of different real estate or mineral interests, yes, that might justify having a trust. But otherwise, most people do not need them. And those who do pay the several $1,000s to a lawyer to create one, a lot of times make a mistake and they forget to fully fund the trust. So it's not enough to draft a document that you sign. You then have to go and transfer every asset that you own that's in your name or your spouse's name. You guys have to go and transfer all those assets into the name of the trust. So every bank account, every investment account, all your life insurance policies, your 401k, your house, your cars, everything. It can't be in your name anymore. You have to go to all those institutions, and in the deed records, you have to transfer everything. Let's say, the spouses are John and Sue Smith, and it's the John and Sue Smith Revocable Living Trust. Well, now you have to go transfer your house into the name of the John and Sue Smith Revocable Living Trust. And a lot of people forget to do that, and then their trust means nothing because there's nothing in the trust. So a lot of people make mistakes with that and they end up in probate anyway. So they've spent thousands of dollars to create a trust that maybe didn't actually have the effect they thought it would have. So I don't have a trust personally. My spouse does not have one. We don't have a family trust. I don't believe it's necessary. And I think it's perhaps a poor use of what for most people is going to be limited funds they want to spend on a lawyer right now to do estate planning. And you can get your estate planning done more affordably by just drafting the 7 documents that we've already talked about. The next trust, qualified income trust, that's for people who are having to qualify for Medicaid and they're trying to move assets away so that they don't have more than that. Right now in Texas, it's about $2,700 a month in income that comes in. That is something that's a very specialized type of estate planning that's done by typically lawyers who focus on elder care issues. Special needs trust. Sometimes there are families where a person is disabled, they're receiving government benefits, where if you were to leave them money when you die, it could throw them off of their benefits. That obviously requires special consideration. Some people, again, these are going to be a lot of the folks that are up there in the revocable and irrevocable living trust. Sometimes someone wants to just leave a ton of money to charity and they may set up a charitable trust. And then the last one is spendthrift. This is for families where maybe they're leaving money to, let's just say it's a couple that are in their mid 60s and they have adult children, but one of their adult children has struggled. Maybe they've struggled with substance abuse, alcohol abuse, gambling addiction. Maybe they've had criminal history. Maybe they have just proven that they cannot manage money appropriately. There might be the desire to set the inheritance up for that person in a spendthrift trust where they can't access all of it at one time and just make really poor decisions with it. Again, that's not typical, but these are the types of trusts. So if you hear anyone talking about a trust, make sure you know what kind it is, what it's used for, and whether it might really apply to you. And if you're not sure, you definitely want to talk to a lawyer about it in great detail. So to kind of help wrap up our thinking about estate planning and probate, usually it's not always the first question that clients will ask, but it's definitely one of the questions they will ask in my first conversation with them. What does it cost to do your estate planning, or what will it cost if I die and my estate has to go through probate? So here in the DFW area or any of the larger metro areas in Texas, lawyers that do estate planning and probate work are almost 99.9% of them charge by the hour. That is how most lawyers in every area of law charge, other than personal injury lawyers. They typically charge a contingency fee, but most lawyers in most areas of law charge by the hour. That is definitely true in the estate planning and probate area. Those hourly rates can be anywhere from $300 to $550 for the lawyer. They'll usually charge a lower rate for their paralegal if they have one. That could be like $125 an hour. It is not typical to have a lawyer quote you a flat rate for estate planning. And usually the reason they'll say that is until they really get into working with you, they don't really know how complicated it's going to be. They don't know how much time it's going to take visiting with you to do all of your estate planning, things like that. And so for their certainty, they prefer to bill you by the hour, and that way they know they're being paid for every single minute they spend with you in person or on the phone. Most lawyers, again, in almost every practice area, should give you a free 30-minute phone call or visit to their office to talk about your issues. The basic will package that we talked about before, the 7 documents, at these hourly rates, you're easily going to pay somewhere between $1,800 and $2,500 just to do those 7 documents. If you then add a revocable living trust to those documents, that price is going to go up several $1,000s. If it's any of the other trusts that I mentioned, those are more specific, and that we wouldn't give you even a ranged quote. We would simply say that lawyer's going to be billing you by the hour, and they'd have to talk with you quite a bit before they could even give you a range of what that fee might be. For clients who will need the full-blown probate process, not one of those little baby probate light actions. If you need a full probate, what says here, independent administration, that is when you have a will that the judge approves as a valid will and says, okay, great. I'm going to name the person you have in here as the executor. You have an independent administration, Mr. or Ms. Executor. Here's your letters. You can go start doing whatever you need to do. That type clean and easy probate where there is a valid will, most lawyers can get that done for you. It's going to cost anywhere from $3,000 to $6,000 unless there's something really weird in the documents or some family member puts up some kind of fight and says, they expected or deserved more. But most of those are going to be clean, easy, maybe can get done in 6 months to 9 months and should be in that $3,000 to $6,000 range. If you die without a will, that is what we call the dependent administration. That process is longer and slower with the court. You have to get approval from the judge for every little thing, every check that's going to be written, every account that's going to be closed, every piece of property that's going to be sold. those are easily going to cost $7,000 to $10,000, and it's not unheard of to see them go quite a bit higher. One of the other things that happens, unfortunately, in those dependent administrations where there's no will, if there's a bunch of different family members and possible heirs, they may all come to court. They may all start squabbling. They may all complain about what the judge is doing or who's getting what. And anytime your lawyer is spending time on your case, they're charging you by the hour, so the rates can go up very quickly. A lot of times people don't realize if you get all your estate planning done correctly, thoroughly, you've had a lot of input from a lawyer, you've really spent time thinking about it, you could do a will today and it could last you for 30, 40, 50 years. And as long as it was drafted correctly under Texas law at the time it was drafted, it will still work for you. But you may want to change both the will and all your other documents if certain circumstances come up in your life. So what are the things that would trigger someone? Even if you've already done your estate planning, maybe you drafted a will 10 years ago and you think it's good for you, but you're not sure, go back and look at all your documents. Did anyone in any of those documents that you have named, has there been a birth or a death? Has someone become disabled? Was there a marriage or a divorce? That may, by thinking through that, you may realize, oh, there's more kids in the family now, and I want to provide for my nieces and nephews. Or maybe someone got divorced and you want to make sure that maybe you were leaving something to your sister and brother-in-law, and now he's not your brother-in-law anymore, and she got divorced. You want to cut him out of the will. So any of these circumstances could lead you to change your planning or to rename the people that would have power over you in the various powers of attorneys and things like that. So that kind of wraps up the broad conversation about estate planning and probate and what you can be doing to have agency and autonomy and power over your process, your desire, how you want your legacy to be thought of and felt by your family. As for me, as Sarah said at the beginning, I came out of SMU Law School in 1993. I have been doing estate planning as a part of my practice all of the years that I've been a lawyer. Now I am what I think of as semi-retired. So the only thing that I do in the law now is estate planning. All the other things I used to do, I've dropped off to the side. So for me, this is part of my legacy, is to continue to help people empower themselves and take care of their families. So if someone wants to work with me as a potential client, or certainly as a client, I start with a complimentary 1-hour visit with people. And it basically is going over everything we just did in this video. If someone actually wants to hire me to do estate planning for them, then what I'm doing is I do offer a discounted flat rate fee for the wills and those other estate planning documents. So that package of 7 documents, I charge people about 1/3 of what is my normal hourly rate for themselves, and a discounted rate as well if it's for a couple. So I'm a little bit easier to work with than some folks, but it's up to the client. You want to work with someone that you feel comfortable with, and I'm happy to have that initial conversation with people, whether they end up hiring me to do their estate planning for them or not. So please don't hesitate to contact me if you have questions. The other thing that I do, and this is sort of a standalone conversation that takes about 90 minutes. It's a talk that I call What to Do When Someone Dies. That is very helpful either if someone has very recently passed away and the family members are trying to kind of wrap their hands and their heads around what do we need to do, or it can also be good for people if somebody is on hospice in particular, where we're anticipating they will die in the next few months, and it's a way to help the whole family come together and think through what can we do, if anything, in advance of their death to continue to kind of tidy things up. Any loose strings, can we get those tied up? And what do we need to do as soon as the person passes away? So I give a 6-page handout of literally what to do in the first days, the first week, the first months, anything you could think of that someone might have to do in dealing with personal effects, property, accounts, governmental entities, all sorts of things. And then I also provide a document, an extensive document for people that explains the probate process. So again, happy to help people any way that I can. And Sarah, I thank you again for letting me visit with folks today. And I'm always available. And if there's anything that I can do to further support you all's efforts at the Dallas Clubhouse or anywhere else, I'm happy to do it.
We are so appreciative of you giving this talk for us not once but twice, especially in this virtual means we can be sharing with others. I was actually briefly talking about it with some oncologists recently, so it's going to be shared far and wide. So thank you.